Good morning, ladies and gentlemen. I think we'll make a start. A number of people who indicated that they would be coming are not here yet, but a lot of them were to arrive this morning in Sydney, and I suspect that they've been delayed. So we will start. Now, on your program, it says that there will be a welcome by the Dean of the Faculty of Law, Professor David Dixon. As you can see, I am not David Dixon. My name is Deborah Healy, and I've been involved in organising this. The Dean sends his sincere apologies. He arrived back from Shanghai yesterday quite ill and has cancelled all his appointments for the week, which is very unusual. So I think that we all hope that he's feeling better quite soon. At the outset, I would like to say that it's great to have you all here, and I would also like to pay my respects. The land that we are standing on, the traditional owners of the land here are the Gadigal people of the Eora Nation, and I pay my respects to their elders, past and present. What we are going to do this morning is we are going to do some presentations concerning the past and current work of UNCTAD. And I will introduce you to Pierre Horner, who is at the back of the room currently. I thought he'd gone outside, so I was thinking, where's he gone? But no, he is here. And I would like to introduce Pierre, who is going to talk to you about the forthcoming work of UNCTAD this year initially. And would you like to come and put your...
Thank you very much. Good morning, all. I am very happy to be for the first time in Sydney, and I would like first to thank for all the support that Deborah and his team and the University as well of Sydney, New South Wales have provided to this event. For those that don't know me, I represent UNCTAD. I work in UNCTAD in the last 12 years. I've been developing capacity building programs on competition and consumer protection policies. And currently, I'm involved in the new global strategy of UNCTAD related to technical assistance on capacity building. And I'm going to explain in the second presentation about what is this new strategy to all of you. I can hear myself here with the echo, I think. Perhaps maybe here because my voice is to myself. I'm hearing to myself with this. So, yeah, it's better. In this presentation, what I would like to briefly go through is the forthcoming conference that we have in UNCTAD, the ministerial conference to review the UN set on competition. The last one was carried out in 2010, in November 2010, and UNCTAD is currently organizing the 7th review conference of the UN set. So I will go briefly to this part. Some of the introduction, you all know perhaps the UN set, just to review and refresh your memory. I would like to talk about quickly and briefly about the UN set on competition. Then I will talk about what aspects of the set we will review at the 7th review conference in July. And then I will leave the expected outlook for the last part of my presentation. As you know, the UN set was adopted by the UN General Assembly in 1980, and UNCTAD was mandated to review the UN set every 5 years. Within UNCTAD, we have a number of ministerial conferences, but in this case, the UN Review Conference, it's basically to review the main aspects of the set and see how it has been implemented in different member states. So in here, you can see that within UNCTAD, we have different type of boards and commissions. We have the IGE, which is as you know, most of you participate at the IGE in Geneva every July. And what we would like to say is that we are the focal point to review all the work and competition policy within the UN system, so there's no other UN agency. And in here, just to make some history, the last time we reviewed the set was in 2010, in November. And we would like to, of course, encourage all member states to participate in this conference. We will look into details about the topics of the conference, which were agreed already in the last IGE in 2014. For those that are not familiar with UN set, the UN set, as I said earlier, was adopted in 1980, and is the only multilateral code of conduct that exists. There was attempts, of course, to have a more binding set of rules at the level of WTO, as you all know, in the area of competition and trade. But in our case, it was a non-binding voluntary code, and there was an attempt, of course, to include, and we included actually as part of the development dimension of UNCTAD, special and differential treatment. So the sixth review conference, of course, was the last conference that reviewed the set and included also 2 peer reviews. Now, the UN set has different type of contents. There are objectives, definitions. There are also the principles of the control of anti-competitive practices. In 1980s, there was the term restrictive business practices. There are also principles and rules for enterprises, including transnational corporations, as well as one area that has been very much exploited, I would say, is in the area of international institutional machinery, because we all meet every year in Geneva, thanks to the mandate of the UN set on competition. One of the main objectives of the UN set, as you all know, is to include the how to ensure that anti-competitive practices do not impede or negate the realization of benefits that should arise from the liberalization of tariff and non-tariff barriers affecting the world trade. And of course, in this area, we also try to include some specific objectives of competition law that are adopted in member states, like, for example, efficiency objectives. So that's coming from 1980, when the situation of competition law development was very different to what is now. And we also included this area of preferential and differential treatment. And this is an area that we have been trying to include, particularly for those countries that are in different levels of development. We also have a different instrument that is being updated every year, which is the UNCTAD Model on Competition, that is coming from the UN set. And we hope that this year we are going to review additional chapters related to this topic. Now, we fully understand there are strengths, there are also weaknesses, but there are strengths of our organization related to the work that we're doing since 1980 on the issue of competition law and policy. What is important here is that we would like to promote a rule-based competition culture, and that's what we have been doing so far through our capacity building programs. Now, going to the detail of the conference, I would like to say that the conference, without actually trying to summarize everything that's going to be discussed in 5 days, but we will have to, as normal procedure, we have to make a report on the assessment of the set in the period 2010-2015. We'll also include a number of topics that were decided last year, which is, first one is the role of competition policy in promoting sustainable and inclusive growth. There's also another topic related to the benefits and the role of competition for consumers in the pharmaceutical sector. So this is an area that we are actually linking up an integral approach of UNCTAD, which is the interaction between competition and consumer protection policies. There is also a paper that I was contributed personally, which is related to the ways and means to strengthen competition agencies in order to better deliver competition policy enforcement and advocacy. This paper has been has consolidated everything that we have done since 2010 in terms of agency effectiveness, in terms of strengthening competition authorities. We have made a review of all the papers and put it a consolidated paper at the end of this period. There's also another paper related to international cooperation in merger cases as a tool for effective enforcement of competition law. I will go to each of these quickly in the next slides. And there's a very important part which have devoted quite a lot of effort from different experts coming from different countries, OECD and non-OECD countries, which is the feedback from recently peer-reviewed countries with competition agencies on enforcements and changes since the peer reviews. So we have relied on different reports that have been done by external auditors. UNCTAD has its own internal review mechanism of the reports we do. So there was an external auditor coming from New York to review this and then travel to these countries and also assess the recommendations of the peer review, whether or not they were implemented, and if not, why not. So the first report, as I said, is the assessment of the application and implementation of the set. In here, what we're going to have is basically three parts. The section one, as I cannot release the paper, it's already finished, but I cannot release it because it has to be released in July. But I can have some ideas, provide you some ideas of what's going to happen. But basically, section one is operation of the set in the field of competition law and policy, looking at its main provision. Also, it reviews a different type of the progress made in each of the resolutions of the IGEs in the last 4 years. And there are also attention that is being drawn to UNCTAD peer reviews. Now, section two will look into the recent developments in international cooperation based on the UNCTAD studies conducted in all the IGEs since 2010. And three, this is the most important part perhaps for the member states, because we will have to decide what UNCTAD is going to do for the next 5 years. So it outlines possible areas in the field of competition and consumer protection policies that the 7th Review Conference might wish to launch for the next 5 years. So this we expect full participation of the member states that can provide additional ideas and areas to work in the next 5 years for UNCTAD. Now, the paper that will support and provide a background note for the high-level segment of the ministerial conference, which is the first day on the 6th of July, it's about the role of competition policy in promoting sustainable and inclusive growth. This is, of course, in line to the UN mainstream work, because, as you know, until 2015, we have, this year actually is being negotiated in New York, the Sustainable Development Goals, the SDGs, and competition policy sort of indirectly is linked to at least 3 of the 20 SDGs. And so this paper tries to explain the relationship between the UN SDGs and the contribution of competition policy. Some of the areas are quite clear for all of you. And this is very important because UNCTAD has been doing this work steadily in all these years, analyzing the relationship between competition and development. Now we are including sustainable and inclusive growth, which is not necessarily the same as development. So this is something that we're trying to also create a specific type of avenues for further research. This is an area where also we try to came up with some ideas about once competition policy is appropriately designed and effectively implemented according to their social economic circumstances of the member country, is expected to complement other government policies. In this regard, coherence, some of the work that we have been doing in the last 5 years about external and internal coherence competition policies with other policies, is something that we picked up in this paper as well, and we developed further. All this research is based on different research that we have done earlier. When it comes to the effective competition law enforcement and advocacy, they, of course, play a key role in realizing sustainable and inclusive development, and through the elimination and deterrence of anti-competitive practices. Of course, this premise and assumption is widely robustly demonstrated, at least in and contrasted with the different realities in different from different continents in this paper. So this is just some of the ideas that we're putting forward here. Applying exception to business government which promote economic progress, environmental protection, green technologies, and products from competition law are necessary to advance sustainable and development goals. So here we're trying to strike a balance between what could be exempted from competition laws and to the attain of all the different goals that from the point of view of UNCTAD are sustainable or could be sustainable. So this is briefly some of the areas we're going to touch in this paper, and will be discussed by not necessarily competition authorities. The idea of this segment is that ministries should also be able to discuss. So we are inviting ministers of trade and development in this section, in this part of the conference. Of course, competition authorities will also be invited to discuss these topics. Now, the second paper, which is going to also be discussed during that week in Geneva, it's about the benefits and the role of competition for consumers in the pharmaceutical sector. In this, there are, of course, principles that we all know related to the link of competition and consumer. But, of course, we try to include here the specific considerations of the pharmaceutical sector. And we try also to go forward by addressing some of the main competition problems in the pharmaceutical industry. In here, we also want to say that not only the competition branch of UNCTAD has participated in this report, there's also other units of UNCTAD that deal with IP unit, and also trade and logistics divisions have participated with their own views, because we try to do an interdivisional paper for the pharmaceutical sector. There's also it gives examples from various jurisdictions on the benefits of competition enforcement for consumers, and recommends enhanced competition advocacy efforts in the pharmaceutical sector. Some of the ideas, of course, are picked up from different case studies we received from the surveys we made to all of you earlier. The third paper is about the ways and means to strengthen competition agencies in order to better deliver competition policy enforcement. This is an ongoing research. In the area of enforcement, we discuss basically two main topics. We discuss what are the substantive elements of the law. And in here, we talk about basically the whole model law of competition, talking about objectives, the scope of application, exceptions, sanctions, etc. But also we discuss the institutional design of the competition agency. And we discuss the tasks and powers of the agency, as well as different type of features that make the agency be effective. So in this regard, we draw conclusions from all the papers we've been working in the last 5 years. The second part of the report is devoted to strengthening competition advocacy. Here, we discuss the experience of competition agencies, how competition agencies can strengthen their advocacy arms in order to strengthen awareness and trust in specialized circles. We do an analysis of strategic communication messages that can be delivered to different types of sectors that are important for the competition agency. So this is more or less this paper about. We are going to also discuss the international cooperation in merger cases as a tool for effective enforcement of competition law, the evolution of international cooperation in the enforcement of competition laws with a focus on cooperation amongst competition agencies in merger cases. So we are going to go through all these reports and developments. It will explore existing cooperation agreements, mechanisms, and networks, as well as their role play as a tool for effective enforcement in both developed and developing countries. The report also looks at several forms of cooperation. So what it will also bring about is additional ways of how to cooperate in merger cases, particularly when there were some good cases. There are also cases to learn from there. So we try to include additional cases, not necessarily the most successful cases, but we try to include cases that perhaps it's good to learn. They are ways to improve them, of course. So, and this is the last part regarding this substantive area, which is the feedback from recently peer-reviewed countries with competition agencies and on enforcement and changes since the peer reviews. We actually reviewed not only the last 5 years of the work of UNCTAD, but we reviewed since the first peer reviews were undertaken in 2005. So this is a 10-year report where UNCTAD developed the peer reviews on competition policy, and we also describe how we do this work. We actually do a process of self-evaluation as well as independent evaluation, and this is all coordinated by UNCTAD. There's also an area which is important to say now, which is related to the drafting of the report. It's not only submitted for examination to authorities of other member states, but also it provides the possibility to different agencies outside the scope of the agencies participate on this report, meaning that not necessarily competition authorities could be able to give opinions of these reports. UNCTAD provides a strategy to disseminate the results in the concerned country to all stakeholders. So there's going to be a follow-up activity. Once the peer review is carried out and presented and discussed in UNCTAD, there's going to be a follow-up in the country. Now, there's also try to collaborate actively in order to try to change the weaknesses found on the competition regulations and to improve the efficiency of the application of such laws. So it means that it's a sort of a need assessment before intervening in the country as sort of providers of technical assistance. So this strategy of UNCTAD is in carrying out reviews among peers has been evaluated positively by most member states who have been subjected to such process. However, it is necessary to create a debate to analyze and propose based on the two external reports. As I said, there were external reports made to the peer reviews on the results obtained in these 10 years, improvements in methodology of its realization. So this is an area that we are taking into account seriously because the analysis that was made in these reports and the opinion that has been generated around them by various experts, I think we have made a round of interviews with different experts. Perhaps some of you have participated as well, for the possibility to contribute to improve the utilization of this valuable instrument that UNCTAD has in order to provide a more efficient and better tailored technical assistance according to the needs of the states. So we try to use and to follow up on the recommendations made by these two external evaluators, and see in this paper actually it's all crystallized. Now, besides that, there's going to be, which is something that we have to do every 5 years. There's a review and perspective for capacity building and technical assistance on competition and consumer protection law and policy. This is something that we will discuss in the next presentation, because we are going to discuss the new UNCTAD global COMPAL strategy on capacity building. So this is something, and this paper actually presents this strategy for the conference. Besides that, we have received the mandate from the member states to review 5 chapters of the UN model law on competition. So there's going to be, and this is in partnership with Eleanor Fox. We have worked together with her and her university. Here we are revising the chapter 1 on objectives of the law. So there's going to be a new paper on this. There's also all the codes are going to be released as of first week of May. You can already look in the websites of UNCTAD, all these codes, this coding of the documents. The abuse of dominance, consumer protection, sanctions and relief, and action for damages. All this is a new release of the UN model law that will be submitted to the 7th Review Conference for consideration and adoption. Last but not least is that the conference will hold 2 additional voluntary pre-reviews on competition law and policy of Albania, Fiji, and Papua New Guinea. As basic document for the peer review of the conference, we'll discuss 4 reports that we have made. So all in all, we have more than 10, 12, 13 reports that we're going to discuss during five days. So it's quite a lot of information that I tried to condense it here in this presentation. Well, when it comes to expected outlook, all I can say is come to Geneva.
Thank you very much, Pierre, for that very interesting presentation, and which shows a lot of the work that's being carried out by UNCTAD and the really strenuous processes of review which are being undertaken to ensure that the work is targeted and is achieving the impact that you wish to achieve. I'm wondering if anyone has any questions for Pierre at this point about what's going to be happening in Geneva, or specific aspects of the workload that UNCTAD's undertaking at the moment. Hopefully some of you who won't decide to come.
It's been touched upon, but from the UNSW, the Advocacy Centre. How will this go for the individual? Because there's a mentioning of individual jurisdictions within the state country. Each part of it, there's some mentioning of different legislations, for instance, the EU. Is this being updated in advance of the meeting?
Yeah. When you send your questionnaires and the updates from the EU law, it's also part of the model law competition. So you will include actually these questionnaires and this update into the model law. Directly. The model law is what we do is basically the model law has its own chapters of commentaries. So we put the text of the model law and we update the the contributions from member states related to the topic itself. So in the case of EU, if you have sent us related to the topics that I mentioned, then it will be there in the commentaries. The UNCTAD, of course, uses the model law competition for the update of the legislations from different member states. So it has to be included in that part. This is the dynamic part of the set. We can always open the set, but then it will take 20 years more to have a new text, perhaps.
So I guess that underlines the importance of sending in very full and well-considered responses to the questionnaires, because it's likely that the material will go into the UNCTAD document, which is, I'm sure you've all seen, but it's quite lengthy as it is, and there are some very interesting examples from various countries in there. I think they show from the point of view of an academic and not a person who is running a competition authority, but they give a really good flavour to the way that the divergences, but also the similarities between the way that various agencies operate, and also the way that the laws are implemented in each country. Any more questions?
Yeah.
Oh, sorry.
Sure. If I understood correctly, the basis of the future work is to make a general review of the model law on protection of competition of UNCTAD in general, yes? You want to review every chapter, so it will be the new model law, or you will just add some fresh and best practices in European Union or other countries? What this work will consist?
Normally, we work under 4 clusters of topics. The 4 clusters are, first one is competition and development.
Yeah.
So the relationship between competition and development, the first paper we are sort of releasing this year is the first one I said about the relationship between competition and inclusive growth and sustainable growth. So the first sort of cluster of topics that UNCTAD will try to continue working on the next 5 years is the relationship between competition and development. The second topic is about agency effectiveness. So it's all related to institutional building, to work directly with the agencies. The first topic is more like directly with policymakers, because it's all about competition policy. The second one is more about competition law enforcement. The third one is about the relationship between competition and consumer protection laws. So it's more about, for example, the paper on pharmaceutical sector. This is a clear example of the relationship between consumer laws, consumer policies, and competition policy. So that's the third cluster and the third one, the last one is capacity building and international cooperation. So this is an area where we have developed a number of papers in the last 5 years. Now, what we expect is that if we all meet in Geneva in July, member states should be able to say, I would like to continue working with these 4 clusters of issues. And perhaps in the first issue, we would like to include more about the work of competition in SMEs or particular areas that are important for competition authorities. Perhaps in the second part, more about working with different type of agencies that have different type of independence or accountability settings that are more detailed for different countries. There's only examples, because I cannot say the outlook because we have to meet first in Geneva. What we put in that paper is just possible areas. I cannot even include the areas because then you don't go to Geneva. So what is important here is that these 4 clusters of issues were decided already 5 years ago, 2010. And they say, well, since UNCTAD is working already on this issue of development, there should be an area where it's always important for countries, which is the relationship between competition policy and not enforcement policy and development. So that's why we continue working on that area. We've made a lot of research on these issues. Now, the last part of international cooperation, more and more countries are asking for informal cooperation.
Yeah.
So we have developed papers on informal cooperation, and Russia has been very active on that as well. So it depends. The model law is just an instrument. It's a tool. We use it for precisely what the colleague from the EU said, because we have laws that are changing, or they are amended, or they are updated. So we can actually include as a mode of commentaries to the model law.
Yeah.
That's, for example, if there's a change in model law in Russia of your law, then we can include it in the respective part of the model law competition?
We basically have an experience. We worked on the model law of protection of competition in Euro-Asian Union.
Yes.
And that's why we took lots of, we revised and we learned more about model law of UNCTAD. So that was the basis in our work for model law on protection of competition in Euro-Asian Union. But the structure of model law of Euro-Asian Union is quite similar as the national laws of any developed countries in antitrust regulation. It's not, it doesn't look like UNCTAD model law because it doesn't contains any commentaries. But we appreciate that the structure of model law on competition in UNCTAD contains such commentaries because it makes the model law really lively, so everyone can understand what's going on. I think that we should not change the basic principles on model law on competition in UNCTAD because these principles are the basis of antitrust regulation in every developing countries. But if we include more commentaries about international cooperation, about the connection between the protection of consumers and protection of competition, if we include some special experience, best practices on regulation of several kinds of markets, such pharmacy, such someone else, it will make our model law, I think, really progressive. So I think this, I understand and I agree that we have some areas and all work groups, all the results of such fields should be included as a commentaries on model law.
Yeah, we're not changing the principle of the text of the model law. We're including commentaries every year. This year we cannot go to the 13 chapters in one go because it's a lot of work. So we chose this year 5 out of 13, which is also quite a lot of work. And thanks to the support of Eleanor Fox and the University of New York, we have been able to finalize this work on time. Already we have in-house papers to make, which are the papers that I presented at the beginning. But then after that, we need to work on the model law as well, because that was committed to the member states.
Yes. Thank you for that. Are there any more comments? Yes.
Mine is just a general one. I'm sort of only interested to find out the scope of competition and development. Development in general, as we have seen the concept of trade and development, which to a large extent, when you look at it, you still have undeveloped countries still remaining undeveloped. To what extent can lessons learned from trade and development be used to support competition and development such that perhaps competition can contribute more meaningfully to the industrialization of developing countries, especially in Africa?
Well, actually, in the first part of if we go to the slides on the objectives of the UNCTAD, which is from 1980, we talk about precisely what you are pointing out. Because in the first slide, when we were talking about the objective of UNCTAD, we said clearly in the objectives, perhaps down. Objective. Next slide, perhaps. After that.
Yeah, sorry.
Objectives, and then there's there. So you can see that in the objectives, we actually put very clear that the objectives of the UNCTAD on competition would be to ensure that anti-competitive practices do not impede or negate the realization of benefits that should arise from the liberalization of tariff and non-tariff barriers. Non-tariff barriers, because an issue of tariff and non-tariff until today, non-tariff barriers, it's a big issue in different countries. Affecting world trade, particularly those affecting the trade and development of developing countries. So basically, this is the major objective of UNCTAD, and remains valid until today, precisely because of the fact you are mentioning. In many countries, in continents, this issue is not yet settled. I can tell you not only in Africa, but in Latin America. There are small countries like in Central America where non-tariff barriers is a real problem for development and for competition as well. For competition rules being developed at the regional level, like the very good model of the EU. That's why we are always looking into the objective of the competition rules, actually to open up markets and to integrate markets, as they did in the EU and historically also in the United States, back in all times. So this is something that we cannot forget, even though it's already more than 35 years since 1980 that was adopted this. Now, but this comes not from 1980. This comes from 1972, when in Santiago, the UNCTAD 6, I think UNCTAD 6, the member states met and they wanted to do a role called sort of a conduct code for ethics for international multinational companies. And that was the first area where UNCTAD was mandated to implement and validate what multinational companies should be able to do and should not do. When it comes to this first word that was sort of touched upon back in the 70s, which is restrictive business practices. Now, we don't say anymore RBPs, we say anti-competitive practices, but still, it comes from these early days.
Yes.
Deborah, can you go to the next slide, the one just below that, where there's a reference to regional arrangements? And it just came up a little bit. That's
Is that it?
B. Yes, that one. Encouraging economic development through regional or global arrangements.
Yes.
I just wanted to ask Pierre, as he knows, I represent not a member state, but the Caribbean community. And I was wondering how, in all of this emphasis on what member states can and cannot do, how we accommodate a regional arrangement, such as the one in the Caribbean or in East Africa, in relation to that part of that strategy for development, which is regional arrangements among small states in particular.
Yeah, I mean, when it was, this comes from the topic of preferential and differentiated treatment, because this was sort of requested by developing countries when it was negotiated, this UNCTAD. It took 8 years to negotiate that since 1972 until 1980. So when they discussed the preferential differential treatment, they started by saying that the purposes of developing countries are basically in 2 areas. And the first area was the promotion of the establishment or development of domestic industries, what you were saying earlier, and the economic development of other sectors of the economy. Now, there's a clear situation here, and that we actually developed later on in 2011 when we did a paper on the relationship between competition policy and industrial policy, because sometimes they clash and there's a tension between them. So we actually came up with some examples about the relationship between industrial and competition. And the second part, which is your question, is about the economic development through regional or global arrangements. Now, on regional, we can say that the facilitation of UNCTAD, this working together with other regional groupings in Africa. We've worked very much in different regions. With WAEMU, we have worked quite a lot. We continue working with the West African Monetary Union. We work also with COMESA. We have worked with CEMAC and other regional groupings, and also we work as a whole African Competition Forum. But in other regions besides Africa, we help regional groupings and networks to do studies. For example, we have done studies on air transport in Latin America. We've done a study in banking sector, in medicine as well. In air transport, it's very clear what is the problem there. As you know, to go from CARICOM countries to any country in Latin America, sometimes you need to go to the United States. It takes 1 day or 2 days, better go to Europe or to Latin America. So it's a real problem for CARICOM economies, the issue of air transport. So because it's part of the area where there are international cartels, there's and regional cartels that are very well developed in that area. So for the ASEAN region that we are now closer, we also are supporting the work of the ASEAN Secretariat in regional economic integration. And that's something that we're going to talk about later on the second presentation, capacity building.
So are there any other queries or questions or comments? We'd like to just make a comment rather than ask a question. No? All right. Well, I guess we need to thank Pierre for his presentation, and it certainly has made me more thoughtful about what will be going on in Geneva in July. I'll be thinking about the contributions I can make. And thank you, Pierre. We might just carry on with the next presentation because we've only started a little late. And after the next presentation by Pierre, we'll have a coffee break, if people are agreeable to that. So I would also like to say, which I should have said in starting, that I'd like to thank the university's Centre for Law, Markets and Regulation, which has been a sponsor of this conference as well at the University of New South Wales. And the centre deals in all aspects of law, markets and regulation. And if you're interested in having a look at what they do, they have a portal with a whole range of documentation on banking law, foreign investment, competition law, and a whole lot of other important superannuation, a whole lot of other important regulation. But I'll call on Pierre to.
Yes, in this we have two commentators, yes, as you know,
yes,
from UNCTAD.
And we have
Fernando and Carl.
And Carl also.
Yes.
So we would like to come up first.
All right. So, but sorry that I'm monopolizing today, but I'm the only member of UNCTAD.
He was so good the first time. We're having him back.
Later on, I won't speak anymore. It's very interesting for me to come up with this because that's what I do day-to-day work in UNCTAD. The other thing is my colleagues. I was trying to interpret what they want to say. So here, what I am actually trying to do, and I think for those that will not be able to make it this time, there's going to be a second presentation by Fernando at the ICN on Thursday, in the World of International Engagement, to which some of these presentations will also be made available. So we all know that UNCTAD is working a lot on competition and consumer policies, more non-consumer policies lately in the last 5 years, because we are currently reviewing the UN guidelines on consumer protection. So we have raised a lot of attention from many member states and NGOs around the world, particularly from the biggest economies. The United States have participated quite a lot on the revision of the UN guidelines on consumer protection, together with Japan, together with the European Union, within EU states, France, Germany, and also China has been very active on this revision of UN guidelines. So there is a voice that they want to create a new IGE on consumer protection, which is based on the previous work of the IGE on competition. It's going to be a challenge because UNCTAD doesn't have so many resources to come up with this big responsibility. And that's why more and more it's important to come up with a new strategy to do our work in terms of capacity building, because that requires a lot of resources, that requires a lot of thinking, that requires a lot of time from different people, member states, absorption capacities also from member states, and also there's a little there's scarcity of resources as well in terms of our donors. So These are areas of work. This is the sort of the classical work of UNCTAD that we're doing, and we're going to reinforce, but with a different strategy. So I don't want to read what it says there, but basically you all know what we were doing since the 1980, when we had the mandate to carry out this work. So all these 4 main areas we've been working. But then in 2003, after precisely what happened in Cancun at the ministerial conference of WTO, there was a voice from a region in Latin America to develop regional competition law. Because member states, as you know, were not ready to implement the multilateral framework of competition. So we saw this momentum, and together with our Swiss colleagues from the Ministry of Economic Affairs, we developed this program called COMPAL in 2003, precisely the same year where competition was out of the WTO negotiations in August. So in August 2003, that was the Cancun Ministerial Conference. In September 2003, we set up the COMPAL program in Latin America. And the objective of this program was to develop and promote sustainable competition and consumer protection system. So the first program that was dealing with the 2 areas at the same time, not only competition, but the other side of the consumer. We started right from the outset of this program with the 2 areas. So, and it became, at that time, the only network that deals with competition and consumer protection agencies in one room. So normally, competition and consumer protection is outside of the competition part. So we actually came up with the integral approach. That's what we do in the branch. We actually work with the 2 areas. And why we did that? Because we wanted to improve the economic performance and competitiveness of the participating countries. At that time, there were only 7 countries in Latin America out of 17 that they are. And we started with 5 because it was a pilot program. Then what we actually been evaluated by, because the donors, our Swiss colleagues are very strict with the funding, so they want to, every time we do 3-year phase, we evaluate with external donors. So they were coming from different countries, from regions, representing different institutions, sometimes institutions that are very, they are specialized on capacity building, not only in competition, but in different areas. And they say that COMPAL has become an efficient platform for its member countries because we have done this holistic and inclusive approach of reinforcing both policies. And also because we try to create additional type of ways to see the same problem from a consumer protection viewpoint or competition viewpoint, or both at the same time. So we actually cooperate on that area. And this sort of topics that they evaluated us during the 10-year program, it's because they said that it was relevant to the countries, particularly because they didn't have competition laws, perhaps, or they had a very small implementation of their laws. It was efficient, effective. Most importantly, above all, is about trust, because if you don't trust what you're doing, then it becomes very difficult to actually continue doing the work. And most importantly, building trust between UNCTAD and the member states of COMPAL has been the major priority of the program. We have also a focus on just the specific needs, not to do too many things at the same time. Just very little, but do it good, do it that can actually build on the next year work. It has been also strategic, because what we did is to talk about the strategic planning of the agency. So we look at the 5-year strategic planning of the agency, and then we only prioritize what is priority for them without our intervention. So we look at first what they want, and later on we complement. So even if the COMPAL didn't exist, they will have to do it anyways. The advisory group of experts is something that Fernando, who is here and he's the founder of this group, will perhaps talk about this with more detail. And the regional component. which is something that we've done also in different regions, because that's precisely what we discussed earlier. There are ways to create multiplier effect with very little funding. There's a ways to overcome regional challenge if we work together. And there's also a case for coherence and greater cooperation when it comes to informal ways of talking between agencies about common concerns. So why now we are going from COMPAL to global COMPAL? Well, because we are talking about here that when we talk about the COMPAL program as such that was developed in Latin America, it actually created an opportunity for Latin American countries to come from 5 members to 15 members currently. So we actually triplicate the amount of members. Why? Because they saw that there was an opportunity for a large thematic global strategy on both areas. Because in COMPAL, the activities have to be shared between the agencies. That means that they take the risks of the activity. That means that if there is a sector inquiry to be made, it has to be made by both agencies. If you talk about medicines, we need to have all the work of the Consumer Protection Agency on monitoring medicaments, products, and market surveillance, and as well as the competition conditions of that market and the market operators coming from the competition authority. So there is a synergy. Sometimes in countries, competition, and the majority of the time, I would say, competition and consumer protection authorities work independently, completely independent. So what we do in this program is we try to create synergy of the work that they do, these agencies at the domestic, and nowadays we do it at the regional level. So there's also another thing that we did, is long-term intervention. It's not a one-shot event. We show up once and we never come back in 5 years. No, it has to be consistent, steadily in the time. I have here my friend Carlos, who made very good contributions in Ecuador when we started the competition law. And it was good contribution because you can see that people were committed to the work. And we continue working with Ecuador now with the judges. So this is something that we do because we consider this type of interventions on a long-term basis, 15 years intervention. We already have 12, so we're going to develop a 15-year program that has for the next years, I hope, until I retire. So on the basis of the experience gains from the work of under COMPAL, our Secretary General of UNCTAD decided to launch Global COMPAL in Peru, because Peru is going to be the venue of the UNCTAD Ministerial Conference 14th in March 2016. So they were signing a memorandum of understanding, and there was an occasion to also launch this Global COMPAL strategy back in May 2014. Now, I would like to make very clear that because we are talking about a global strategy, we have, with the consent of all the hierarchy of UNCTAD, as well as other member states and donor countries, we have sort of changed the meaning of the word COMPAL to the new meaning that is competition and consumer protection policies for all. The logo for UNCTAD, as well as, is prosperity for all. So it's sort of the same motto that we have for our program. So this new strategy has a new meaning, COMPAL, which is competition and consumer protection policies for all. Now, you cannot see in the map, perhaps, yeah, you can see, but very little. This is a world map. And you can see that we started here with the own logo, and then we have launched the COMPAL MENA for the MENA region. And then we also work since a long time ago, parallelly to COMPAL Latin America, in the WAEMO countries, WEMOA. And then we are piloting a project on consumer protection at the ASEAN regional project. And we worked parallelly with Sofia Competition Forum for 10 Balkan countries. And we hope also, with the support of Russia, to actually come up with the COMPAL CIS, actually, with 10 countries, additional countries. So this is sort of the idea of the work that we're going to cover throughout the world. Now, I put new features in terms of the integral approach because it's a global approach. It means that the activities will have to work with competition and consumer protection issues at the same time. And now we are adding the component of the global component, which is precisely the work of UNCTAD. You know? Working as a UN agency, we need to cover the whole world. So the global component will be also a very important part of global COMPAL strategy, because it will allow us to systematically share the experience between different regions that they have their own activities. And what would be the vehicle of this sharing? One important feature is the regional advisory group of experts. For example, here in this table, we have Fernando Fulan, who was the member of the advisory group of experts of Latin America, but recently he has participated in the MENA region, doing field visits with UNCTAD, bringing the experience from Latin America to the MENA region. So this is the same person who was in Latin America, now goes to the MENA region, and could be also vice versa from different regions. Also, the members of Global COMPAL will have access irrestrictly to all the COMPAL products through a database, which is being put at the disposal of the members. And we will have all the UN languages available, the 6 UN official languages. Now, what are the regional programs we have currently? We have the Latin America, we have the MENA program, we have the piloting in the ASEAN region, and we are forthcoming programs, we hope, as I said, with the CIS and the Balkan regions. Now, the program on MENA started in December 2014. Currently, we're doing the field visits. We already undertook 1 set of field visits to 3 countries in the MENA region, and there's going to be 3 more countries to visit it in order to have a need assessment phase and inception report. And you can see here, the objectives are very clear on this issue. And then, of course, there's going to be an area where we're going to develop quite clear, which is work with the private sector. I think I made some small change to this presentation. Perhaps it's in the other file. Because I made small changes. All right, well, that doesn't matter, it's not a problem. So the main strategic part of intervention of these programs are basically 3 areas. First, we have working with competition and consumer agencies on strengthening their capacities on competition and consumer protection. Secondly, this is a new component of global strategy, is working with the private sector to develop guidelines for voluntary compliance of competition rules and consumer protection rules. And the third one, which I'm not going to expand too much, is about competition neutrality, which is coherence between policies, which will be part of the last presentation by Deborah. And all these regional programs are actually developing at their own level these objectives. For example, as I said, the MENA region has its own objectives on competition and consumer protection. Objective 3, which is assistance to the private sector in the MENA region. Objective 4 is about competition neutrality frameworks. And Objective 5 is how to facilitate the accession of the new members into global COMPAL work. In Latin America, because it's all being ongoing work, we are focusing on 2 objectives. Legal frameworks, which is similar to the work of consolidating our first phases of this program. And second objective, which is the compliance of private sector, support for the compliance of private sector with competition and consumer protection laws and policies. And all these countries are part of beneficiaries. There are, of course, consumer protection agencies, but competition agencies in the case of for example, in different countries, there are different competition authorities. But in the case of Mexico, for example, is the Consumer Protection Authority, who is member of COMPAL, not yet the Competition Authority. But the Consumer Protection, it's full member of this new strategic part. The COMPIA Sofia Competition Forum, it's something that we already started in 2011 with the Bulgarian Competition Authority. And we have already worked with a different type of outputs. There's a report on comparative overview of Balkan competition regimes. There's also, let's say, it has provided an excellent opportunity for active international cooperation, and that's something that we will carry out in the future. And we have a new meeting scheduled for 29th of May in Sofia. As you can see, these are the beneficiary countries. The most advanced, of course, are Croatia and Bulgaria, and the rest, they are working towards the development of their own rules. This is only about competition. So the challenge here in this region is first to approach consumer protection authorities of these countries. They are also invited to the meeting in Bulgaria on 9th of May. And what we're going to do is to present the possibility to launch a program for them with the support of our donors that work together with us on Global COMPAL. So there is an area of work that we'll be developing. The idea is to set up this program quite soon. And since we are near the ASEAN region, we have signed a cooperation agreement with the ASEAN Secretariat to develop a regional project on consumer protection. But this is an interesting part because we have developed sectorial consumer protection activities, which are working into these 6 areas, as you can see here, on product safety, internet, e-commerce, and so forth. The idea is that here, next year, we're trying to include competition authorities as well. We're working individually with competition authorities, but not at the regional level like we do with consumer protection authorities. And it's covering 10 member states. So this is what I wanted to say on this part. I think that I had the possibility to send to all of you the registered emails, the latest version of this presentation, because I include the main strategic interventions of Global COMPAL, which are related to these areas that I was saying. And of course, the regional programs that we are trying to develop here are in direct relation to the Global COMPAL work. And this will be also what we discussed earlier for the conference. This is part of the paper that we are releasing of the outlook of the capacity building program of UNCTAD for the next 5 years. So that's more or less what I wanted to share with you. Thank you. We will cover. So, yes, I mean, yes. Because it's
Well, if there are no questions of Pierre, does anyone have a question of Pierre at this point?
No coffee break.
One at the back, yes.
Thanks, Pierre, for an interesting presentation on risk of the financial service. One of the things that we sometimes find is that it's really easy to connect with competition authorities because there's just and where you can have quite a diversity of consumer regulators in a country. I'm just interested with the experience in Latin America, whether working as you've done in that space for quite a few years, there's become a sort of a cohesion between the competition and consumer regulators, or even more of them being in the one regulator we are actually see. So has it had any influence in that way?
Yeah, can you go up to the front? So
yes.
We're live streaming this event on the website, so it's probably more appropriate that Pierre answers.
If I answer correctly your question, Bruce, it's that what were the challenges that we face to talk about competition and consumer protection issues with regulators? in Latin America during 10 years. That's what I understood.
Yeah, and
So I
whether,
didn't hear very well.
whether in doing what you've done, you've influenced, so there are more competition agencies that are also the consumer regulators in that Latin American space, or they work more closely together, because I think we find that they're often quite.
Yeah, I understand your question, yes. Well, first of all, in Latin America, there are at least 3 authorities that are umbrella agencies like Australia. There's the Colombian agency that deals with competition and consumer protection and industrial property as well. There is the Panamanian agency that deals with competition and consumer. And there is the Peruvian agency that deals with competition, consumer, and 7 more issues, including anti-dumping. And this is a big umbrella agency. I'm not sure about any other agency in Latin America, Carlos, that deals with that. I don't think so. So there are only 3 countries. The rest are all independent, and very much independent. Sometimes they don't see each other, the faces. So it's true, the work has been difficult at the beginning because they have their own agenda, and it's difficult sometimes to influence what could be done if there is no willingness to do it. So the majority of these countries, first of all, consumer protection laws were before competition rules. In the majority, I'm not sure in Australia, but at least in that part of the world, consumer protection rules were before. So they were adopted sometimes in the 70s, sometimes in the 80s, and then in the 90s, competition rules started to establish with competition agencies, but they were also separate for consumer protection agencies. So in some countries, to adopt competition rules, you have to sell to policymakers through consumer protection measures. So if you go to a parliament like Costa Rica, you sell the competition agenda with consumer protection rationale, you know. Otherwise, it will not pass in the parliament. So there's an area there where we have actually used the advocates for consumer protection, also law professors that are prestige in the country, to talk about these issues, public media and these type of things, to support and lobby for competition. So after the competition authority was established, but separately from consumer protection authority, then they started to have turfing problems because everybody wants to protect their own thing. So what we did is to what we did was to incorporate in the strategic planning of our programs some ways of synergy. For example, if we do, as I said, if we do a sectoral study, we actually invite the consumer protection experts to talk about the precise sector that they are familiar with, to actually provide opinions, to provide data for the competition authority head of the investigation unit. And it worked pretty well, but there's no memorandum of understanding. There's nothing. Actually, what we do just is in our COMPAL meetings, there is the competition authority from one side, there's the consumer protection on the other side, and we just combine efforts, and we actually facilitate the program by actually including the data that we have asked separately. So you see, so after that, it makes sense when you present the program with the report, where there's so much data combined, consolidated, and then after say, but that was interesting, that we should have done before. Yes, but at the beginning they didn't want to. So the report was made available, and the second or third or fourth or fifth, we have to consider it, of course, from different countries, not to accuse anyone, and then go into detail about presenting the report. So on telecom, also airline industry as well, we have done quite a lot of work on that issue. So using these examples. Nowadays, because 12 years have passed, now it's very easy to sit down with consumer protection authorities and competition authorities to come up with activities that will benefit both of them. But these 3 competition and consumer protection umbrella agencies of Peru, Colombia, and Panama, they help also a lot in sort of undertaking these projects. Another example will be on advocacy as well. Advocacy is quite a big area of this authority because they are younger agencies, so they need to work a lot on advocacy. So we used quite a lot of the work of the consumer protection authorities to advocate for competition specific related projects. So it was quite interesting. But at the beginning, it doesn't work. But you need to be perseverant and long term. And it may at the end of the day. Yes.
Hi, I'm May from UNSW New South Wales. I'm together with Deborah in our course on ASEAN competition and all. I'm interested in this aspect about consumer protection in ASEAN, and you've listed the 6 areas that UNCTAD works with the ASEAN countries. And relating it back earlier to your presentation on COMPAL, which is really interesting because it now covers the whole global network. There was special emphasis about the pharmaceutical sector. So I just want to know whether this will be a main emphasis together with product liability, product safety and all, and to what extent have that work commenced and be progressed in this area?
Yes. Well, actually, we just finalized the second set of field visits. We have visited 6 countries in the ASEAN region. The first one we started in November and December last year. And now we combine this ICN work with the work on consumer protection in the ASEAN region. So we were in Malaysia, in Brunei, and Singapore to do this work. And it's quite interesting, actually, to see, because in all these countries, we started from the beginning, perhaps because of what I want to relay also to what Bruce said earlier. Since you start from the outset to relay the work of competition authorities and consumer protection authorities, in the case of Malaysia, for example, we were just for this work of doing sectoral enforcement of consumer protection rules in the 6 areas of work: product safety and labeling, pharmaceutical, healthcare services, professional service, legal service. But these all sectors have an impact also on the competition conditions. So despite the fact that we only were interviewing sectoral regulators on consumer protection, we also made analysis of competition-related activities, and we also talked to the Competition Commission of Malaysia. And that go back to here, because the approach that we are doing to here is to talk about the main stakeholders on healthcare services and product safety. On product safety, we have food safety. On healthcare, we have the Ministry of Health, because in these countries it's very important, the Ministry of Health, but also we have the medical services within professional services. So they are overlapping, sort of. If you don't separate it from the outset, you can really mix up all these sectors in one go. At least 3 sectors: product safety, healthcare, and medical services within professional services. So what we did is to make direct interviews with these regulators. Sometimes they are not only regulators, but they are NGOs that have mandated to be sort of the regulators in that sector. And we try to provide specific surveys for each of these stakeholders, because what we want to produce out of it is training materials on technical and soft skills for consumer protection enforcers, case handlers. So in case of your question of pharmaceutical, we have made an analysis based on our preliminary results of the paper I just mentioned for the 7-week conference, and we have included a number of questions that are related to the pharmaceutical regulator, because in these areas there are a bureau that deals with that. In the case of your country, Malaysia, I think we also had the possibility to meet with them, and also they provided us with their own views. Now, our work is to process everything, because we cannot have 6 regulators on one sector only. It will be a very difficult project. It will be impossible to handle. So we have to really condense and process that information we receive, because there are different vested interests. If you talk with the National Pharmaceutical Control Bureau of your country, they will think very differently from the other stakeholders within the Ministry of Health. So that's why we need to be taking into account what they tell us, and then we process the information, and we, of course, get back to them with a report. So we are actually progressing on that. We have finalized just yesterday. Actually, no, as we speak, there are 2 more days of work. Our colleagues stay there until tomorrow in Singapore to finalize the field visits. And we would like to, by the end of July, present a first draft of training materials for a validation workshop for the 10 member states. And we will meet in Indonesia with the ASEAN Secretariat headquarters at the end of July to present and say whether these authorities say, oh, I'm going to use it, oh, it's not relevant for me, oh, thank you very much, but we don't want that. So we need to really see whether this is useful for the authorities, because our idea is that these training materials should be able to be used on a daily basis, because they are for competition, for consumer protection handlers. Now, this also is helping us for the competition part, because as we are talking about the global strategy, all this information, what is relevant and applicable to competition handlers on these particular sectors, we should be able to adapt to them as well. So not only for the 10 member states of ASEAN, but for the 453 member states of global COMPAL around the world. So that's also the idea that we will do once the training materials are ready.
Another question.
Carlos.
Well, first of all, congratulations for this improvement of the COMPAL program. I think it's very important. It's a result of your personal work, and I think it's very interesting what you achieved, especially in Latin America. I think one of the best contributions of COMPAL in Latin America was capacity building, training investigators and mid-level officers in the competition and consumer protection agencies. Is this something you will continue in the rest of the programs, or are you changing the strategy?
No, actually, we're not changing. We are reinforcing it, because the idea of the first objective out of the 3 main objectives global is to continue doing this part of work, capacity building to middle and sort of the forces that are day-to-day there. You were part of some of the work that we did, but there's one difference perhaps from the past, and is that we will incorporate not only jurisdictions that are closer to these countries, but also they are not so much close, but with the same level of development or similar level of development. For example, if we talk about the situation in let's say in Malaysia, where there is a younger competition agency, but with a lot of perspectives to actually be rapidly developing, there's a number of guidelines and there's resident advisors as well that are working from South Africa. We just learned that in our visit. So why not replicating that experience in a country that also started like we were together in Ecuador? So this is something that will incorporate additional richness to the program that was not before. In the work that we have carried out, there's one thing that we will develop even more salient. I would say the work of post-mortem investigation cases of similar cases for the same sector. In Latin America, there was at least 3 sectors that have been currently developed parallelly in the last 10 years. For example, the liquid oxygen sector, there were 10 countries with 10 different resolutions because there was no cooperation between the 10 countries. Starting from our colleagues in Argentina, Chile, then Brazil, Panama, Mexico as well, in the same sector. So there were 7 jurisdictions, and unfortunately, cooperation was not made because of domestic regulations concerns and some other factors. So what we're going to do is to strengthen that part. The same thing we will do in the ASEAN region. I mean, in the ASEAN region, there is a big area which is totally unexplored, I would say, which is the area of unregulated sectors that are carried out constantly by the competition authorities. And now the usefulness of working together with consumer protection regulators is that because we have data, we have product, we have market surveillance, live data that is being gathered every single day by this we learned with our field visits that there's quite a lot of data that is available but is not known. So because of that, we can actually provide additional insights about specific sectors that are cross-cutting in these, for example, 10 member countries of the ASEAN region. The same thing on the cement sector in Latin America, where you had cases that were clear, and more also there are sectors like the pharmaceutical sector that is also recurrent in different jurisdictions. And once again, the problem of no regional cooperation mechanisms that are effective in the region allow them not to cooperate on case investigation, because more and more regional markets are going back and going better. So that's why our global component of this strategy will talk about these markets. What is happening in Malaysia or in China will have an impact in Mexico immediately, or in the CIS region, or in the MENA region, or anywhere in the world. So that's why the global component will be helped and supported by the regional advisors of each of the programs. So, for example, if Fernando, who is based in Brazil, he heard something that is happening that is impacting Brazil, but in China, from China or from any other country, then we will alert our colleagues from the ASEAN region to actually look into this problem. So that is a global component about it. So there's a sort of a cross-fertilization between regional programs. This is something new. We didn't have it before.
Well, if there are no more questions at the moment, we might break for morning tea and come back to hear from Fernando and from Carl after the break. So thank you very much.
Thank you.
Yeah.
Very much.
We will come back in 15. We'll come back at 11. I think.